Hello, everyone, and welcome back to the IDPC podcast. I'm Franco Loisio, Head of Communication of the IDPC. Today, we are discussing the topic of data protection rights, and I would like to welcome the Chief Legal Counsel at the IDPC, Kathleen Xerri. Welcome, Kathleen.
Hi, Franco, and thank you for the invite.
Pleasure. Data protection has become one of the defining legal challenges of the digital era. At its core are the rights that give individuals control over how their personal data is used. So what exactly are the core rights that data subjects have under data protection law?
So, the idea behind data protection rights is to empower data subjects and to enable them to exercise meaningful control over the manner how their data is being processed by the controller. A controller is an organization, a public authority, an entity that processes personal data. As a supervisory authority, we have seen an exponential rise in the number of data protection complaints, in particular the last few years. This demonstrates that the data subjects are increasingly becoming aware of their data protection rights, and more importantly, they are questioning the actions of the controller. In fact, one of the rights that we regularly see exercised is the right of access in terms of Article 15 of the GDPR. This is commonly known as the Subject Access Request, the SAR. So this is a way of saying that as a data subject, you have the right to ask any organization, any entity, what personal data do you have about me? How are you processing my personal data? For which purposes are you processing that data? And this is indeed a very powerful tool because it enables the data subjects to receive a copy of their personal data, including also information about the processing activity. For example, for how long the data shall be stored. So here, the data subjects are empowered because they can know what the controller is processing about them. If the data subject is not happy about how the data is being processed, then the data subject may exercise other data protection rights. For example, the right to rectification, the right to erasure, and in certain instances, the right to restriction. Another right which we regularly see exercised is the right to object. This often pops up in cases of CCTV cameras. For example, an individual decides to install a camera overlooking neighboring properties or public space. So the neighbor is not happy with that camera, and the neighbor can object to the processing undertaken by means of that camera. Another instance where we see the right to object is within the context of direct marketing. We all have received a promotional email, a promotional text message, and in these particular cases, the data subject may decide to object to the processing. So here, the controller is legally required to stop the processing. No questions asked, but the data must go. And lastly, I wanted to briefly mention the right to erasure. This is commonly known as the right to be forgotten. And as a data protection authority, we tend to see this right mostly exercised within the digital environment. And this is when the data subjects request the controller to remove their personal data from online news portals or any other website. It is also exercised vis-a-vis search engines, and that is when the data subject requests the controller to remove the search results. So in these particular cases, the controller is required to erase the data if the data is being processed in an unlawful manner or if it is no longer necessary.
Thank you. The IDPC regularly receives complaints from data subjects concerning alleged infringements of their data protection rights, as you've been mentioning. What is one of the topics that typically forms the subject matter of complaints lodged by data subjects concerning alleged infringements of their data protection rights?
Well, yes, we do receive a substantial amount of data protection complaints in relation to alleged infringements of data protection rights. One of the most common issues that we encounter is that the controller fails to respond to a data protection request within the time limit established by law. So the data subjects can exercise any of their data protection rights directly with the controller. So the rule is very clear, it's very simple. Once a request is received, the controller must act without delay and the latest within a month from the date of receipt of the request. So this is not a guideline, it is not a best practice, but it is a legal requirement.
Okay.
The GDPR is very stringent when it comes to the time limits, and this is why we always advise controllers that when they receive a request, they must act with urgency, almost like a ticking clock. So that is why we always advise controllers to respond as quick as possible.
Okay.
So the idea behind this is that the data subjects shall not be left waiting indefinitely for answers over their own personal data. So it is intended to empower the data subject and to also hold accountable the controller. So whilst it may seem like a small procedural issue, however, in reality it usually speaks of bigger problems. And this is because here we are talking of rights being denied. So as a data protection authority, we tend to see that controllers miss the deadline for various reasons. It could be because the controller is overwhelmed. We do see cases where the controller receives huge volumes of data protection requests, and some of these are very complex. And then we also encounter cases where the controller is underprepared. And here the controller does not have the appropriate processes and procedures to be able to handle the request. And lastly, unfortunately, we do encounter cases where the data protection where the controllers are not aware of their data protection obligations. And this brings me to my next point. I wanted to briefly mention a judgment which was delivered by the Court of Appeal. This is quite a significant judgment because it is the first time that our national courts ruled about the time limits in terms of the GDPR. So the facts of the case very briefly, there was a mother, she exercised the right of access on behalf of her minor son. The controller was a public authority and did respond to this request. However, the response was 6 days after the 1 month deadline. So really and truly, a delay of 6 days is not an excessive delay. We have seen delays of weeks and unfortunately sometimes even of months. So the court, however, was very stringent. It adopted a very strict approach and it decided that even a short delay constitutes an infringement of the GDPR. So in my opinion, the court sent out a very strong message that the time limits are there to be complied with.
Okay. Are there any limitations or restrictions on these data protection rights, and how can we ensure that these respect the essence of the right to the protection of personal data and remain lawful in practice?
So yes, this is very important. The right to the protection of personal data is a fundamental right. However, it is not an absolute right, which means that it may be balanced out against other fundamental rights and freedoms, but subject to the principle of proportionality. So in simple words, a right may be restricted but subject to very strict conditions. So we must always keep in mind that a restriction shall be treated as an exception to the general rule. Well, the GDPR does not define what is a restriction. However, we always interpret a restriction to be a form of limitation or suspension of a right whenever there is an important objective. This could be, for example, safeguarding an important objective of general public interest, matters pertaining to national security, criminal investigations, judicial proceedings, public health, and the list goes on. So just to give a practical example of how a restriction can be invoked in practice, so let's say there is a law enforcement authority that is conducting a criminal investigation. The suspect requires a copy of his personal data from the controller. So in this case, the controller may decide to restrict the right on the basis that the disclosure of that information may prejudice the ongoing investigation. So this is a practical example as to how a restriction may be applied in practice. Well, we must also keep in mind that a restriction must always meet very strict and specific conditions. So first and foremost, it must be based on a legislative measure. So there must be a law that enables the restriction. So in our case, we do have a subsidiary legislation under the Data Protection Act that provides for a list of grounds that enable the controller to rely on to restrict a right. Secondly, and this is also very important, a restriction must be a necessary and proportionate measure in a democratic society. So what does this mean? It means that before a controller restricts a right, the controller must undertake a very strict necessity and proportionality assessment. So first, the controller must identify an intended objective and then determine whether it is strictly necessary to restrict that right in order to be able to achieve that intended objective. And if the controller manages to demonstrate the necessity of the restriction, then the controller can move on to the second part of the test, and this is the proportionality aspect. So here the controller will be determining whether the restriction is proportionate, well-balanced, and not excessive in relation to the intended objective. We always advise controllers that as much as possible they should consider partial disclosure and that the data subjects should be informed of the reason of the restriction, unless doing so would undermine the very purpose of the restriction. A word of advice for the controllers, we always emphasize that the necessity and proportionality assessment should be documented. And this links to the principle of accountability, which is the cornerstone of the GDPR. And this principle provides that the controller should not only comply with the GDPR, but should be in a position to demonstrate that compliance. So for this reason, we always emphasize that the assessments should be documented, dated, and periodically reviewed to ensure the continued applicability of the restriction.
So what advice would the IDPC give to a controller on how to properly handle data subject requests, especially as the volume of requests continues to increase? Are there best practices you recommend for managing requests efficiently and in accordance with the GDPR?
Yes, one of the issues that we encounter is that sometimes the employees of the controller do not recognize when a data subject is exercising a data protection right. So usually what happens is that an email sits in the inbox of the employee and a whole month passes, and then that is when the commissioner receives a complaint. This is because the data subject sent a data protection request to the controller via a channel other than that preferred by the controller. We must always keep in mind that when the controller receives a request via a reasonable channel, then the controller must act and respond to that request. So it all boils down to training the employees to be able to recognize a request. A request does not need to contain any legal jargon. It does not need to specify the legal provision upon which the data subject is relying to exercise a data protection right. In fact, the data subjects are not even legally required to do so. So it is important that the employees are properly trained to be able to recognize a request and to pass on that request either to the data protection officer if designated or to any other officer within the organization that is responsible for handling data protection matters. So the second advice that I would give, we do notice that when controllers are well prepared and they handle requests in an appropriate manner, it is because they are well prepared. They have in place internal processes and procedures to be able to effectively handle a data protection request. So being well prepared and having clear procedures is key to reduce the number of infringements and ensure timely compliance with the GDPR.
Okay, and finally, we know that different sectors face different challenges when it comes to data protection. What kind of trends or patterns has the IDPC observed when it comes to handling data subject requests?
Yes, we do see some trends and patterns. For example, certain industries like the gaming industry, the financial sector, the public sector, they tend to receive more data protection requests, and the reason is quite obvious. They do process huge volumes of personal data, and it's also due to the nature of the processing activities. As a result, they tend to also attract a number of data protection complaints. On the other hand, then we do encounter cases where the controller receives a one-off case or an occasional request, and here the challenge is completely different. This is because the controller may lack the experience, and sometimes they do not have the appropriate internal processes and procedures to be able to effectively handle a data protection request. So here, unfortunately, we see the unintentional infringement of the GDPR. So whether you are a controller dealing with a high volume of data protection requests or a controller dealing with an occasional request or a one-off request, the controllers must always be well prepared and understand their data protection obligations, because both scenarios can pose significant risks to the rights and freedoms of the data subjects.
Very interesting subject indeed. I thank you, Kathleen, for that useful information and for joining me in today's episode of this IDPC podcast. And would like to thank everyone who is listening and viewing. See you next time for another episode of the IDPC podcast.